spend in the legislature and both houses, if I'm not mistaken. Have you ever known anyone to serve as in the House, in the Senate at the same time?
No, but I put in a bill to make the General Assembly unicameral.
The answer is no, right?
No, no one's ever done that.
Have you, in your political history, have you ever known anyone to hold two public offices, elected offices at the same time?
I haven't. No, I haven't.
All right, that's all right. I got another thing I want to ask.
Actually, no, I haven't. I haven't.
The other question is, you said we can do it tonight. We voted on the last meeting, and I don't know, maybe I'm wrong. You can correct me if I'm wrong. Therefore, to change that would require a vote of reconsideration, and that would require us to take action tonight and put it on the meeting in January, not this meeting, if I'm not mistaken, by parliamentary procedure. It's not like a vote of reconsideration taken that night where somebody in the majority has to vote on it. That's gone by. Now we're at a new meeting, and therefore in our bylaws, all right, we can't vote on new stuff tonight. It has to be at the next meeting, so it can't be done tonight. No, correct me if I'm wrong. Maybe you're not familiar with our rules of order. So it wouldn't be even legal to do it tonight if the majority felt they would want to do it. It would have to be in January. I don't know, maybe Mr. Anderson could tell me.
Well, you know what? I'll make it much easier for you. If you want to put Mr. Felkner back at this table.
No, I don't want to.
Well, all right. Well then, okay.
Yeah,
well, thank you for your candor. I appreciate that very much. However, if the body wanted to put him back at the table and they wanted to take a vote tonight, I think they probably could. Number one, because I raised that in my letter, and the letter is on the agenda. If your own rules required that you do it in January, that's fine. That's fine. I don't think that you know, we're already substantially through this meeting, so it's a matter of degree of how much he would miss if you didn't do it until January. But if there was a will to do it, I think January would be fine. I think that would be an excellent gesture to put it on the agenda in January to vote to put him back on. Although I do think you could do it tonight.
Okay, I was opposed to this whole action at the last meeting for many reasons, and I didn't want to go into a long diatribe this evening, but I think we acted incorrectly at the last meeting. I don't think we had any right to remove Mr. Felkner from this. We keep talking about conflicting office holding with the legislature and the Senate and the House of Representatives. We're talking about a school committee and a town council. We're comparing apples to oranges here. We're also referencing, well, we've got a copy of the letter from our attorney where he talks about Mr. Bailey that wasn't allowed to serve in South Providence because he was convicted of a felony. Well, Mr. Felkner wasn't convicted of a felony. We're trying to make comparisons that don't exist. I had a chance to review the Hopkinton Charter between the last meeting and this meeting, which I didn't have the opportunity at the last one because this item was not on the agenda last time. And in my opinion, we violated the Open Meetings Act by taking a vote on an item that was not on the agenda, when this evening, clearly, here it is on the agenda, but now we're saying we can't take a vote on it. But the Hopkinton Charter says that no more than one elected position, they cannot hold no more than one elected position in town government. The school committee is not part of the town government. It's a separate entity created by the General Assembly through its own document, the Chariho Act. Therefore, that argument does not apply. The argument in Attorney Anderson's letter regarding Mr. Bailey and his felony convictions, Mr. Felkner did not commit a felony, at least as far as I know, therefore it does not apply. Common law doctrine of incompatibility, and I'm being as succinct as I can, deals with two governing offices in conflict, with one under the supervisory control of the other. The two offices are not in conflict. The town council does not have control over the school committee, therefore it does not apply. As I stated, I believe the last time we violated the Open Meetings Act by voting on something that was not on the agenda. We also violated Mr. Felkner's civil rights because we said not only could he not participate in that meeting, but he can't participate in any school committee meetings. That was the motion. So if we were to adhere to the motion, he can't even speak when he's here because that's what our motion was. Due process was completely ignored. Mr. Felkner was not even allowed to speak at the last meeting. We talked about him. He sat at the table for a while. We refused to acknowledge him, which I believe was inappropriate. If we want to get into this whole legislative who can and who can't disqualify people, Article 1, Section 5 of the United States Constitution deals with the legislative branch of each house. The Rhode Island Constitution, Article 3, deals with qualifications for office. Section 1 regards holding civil office. Section 2 regards disqualification for felony or plea of nolo. Article 6, legislative power for General Assembly members. Each house judges the qualifications of its members. Nowhere in the Chariho Act are the school committee members granted those powers, such as those in either the U.S. Constitution or the Rhode Island Constitution. Now, had I known this was going to be on the agenda for last meeting, I would have prepared and perhaps, stated my case a little better. Knowing that it was on the agenda tonight, again, I don't think we had any right to throw off Mr. Felkner last time. I think we violated the Open Meetings Act. I think we violated his civil rights. And therefore, I'm going to make a motion to allow Mr. Felkner to serve as an elected member of the school committee until ruled otherwise by a court of law.
Second.
I wasn't prepared to actually accept motions on this. I was expecting it to come up on the next agenda for this position. I agree with Mr. Pulaski. We allowed them to speak, to be heard, the letters on the agenda, but the actual act of rescinding our vote is not on this agenda. So I wasn't going to accept this agenda item until next meeting. Mr. Pulaski?
You have a motion and a second, right?
Yeah.
I think that I would like to hear from our legal expert in regard to the legality of this motion tonight, whether it's proper, before we vote on it.
Now, be heard, Madam Chairman.
Yes, please.
Ladies and gentlemen of the school committee, thank you. First of all, I want to thank Mr. Gorham for his cooperation. I appreciate very much that he has conducted the dialogue that we've had with regard to this matter in a dignified and appropriate way that you as a school committee expressed. With regard to the appropriateness of the motion here tonight, the school committee has adopted rules of conduct. This was the subject of numerous meetings. It was also the subject of a subcommittee that met on many occasions. In your rules of conduct, you voted, there were two parts that are relevant. First of all, you indicated that in the event of a default, where the rules were silenced, that you would apply Robert's Rules of Order. Under Robert's Rules of Order, it provides that the motion to rescind a vote can be put on the next agenda, provided a member of the body specifically explains at this meeting what the motion will be. It is not, as Mr. Pulaski indicated, it is not a motion to reconsider. A motion to reconsider is made at the same meeting. It requires a 2/3 vote and has to be made by somebody on the prevailing side. This is a motion to rescind. You voted a motion at the last meeting. Your minutes reflect that you voted a motion at the last meeting. In order to rescind that, one member of the committee has to give notice to the rest of you that I am going to make a motion at our next meeting to rescind the prior motion. That's the first source of authority. The second source of authority is your own rules of conduct. In your own rules of conduct, you specify that items would be put on the agenda through a specific process. That process is either you announce that you're putting them on later at this meeting, and there is a specific time for you to do that, or you provide the committee